dealing with an abusive or high conflict co parent, child support is not just about money. It's about power, leverage, and control. And today, I'm going to tell you what abusers do not want you to understand about child support. Because once you do, you stop being controllable. I'm Tiffany Lesnik, a family law and domestic violence attorney and the founder of Live Free Legal. I work with women navigating divorce, custody, and post separation abuse. And child support is one of the most misunderstood and weaponized areas of family court. Before we go further, I want to be very clear. This video is legal education, not legal advice. Family law rules vary by state, and nothing in this video creates an attorney client relationship. If you need advice specific to your case, you should consult with a qualified family law attorney in your area. So, child support is not optional. That is truth number one. The first thing abusers don't want you to know is this: child support is not a favor, it is not generosity, and it is not optional. Child support belongs to the child, not to you. Courts calculate child support using statutes and guidelines, not narratives about fairness, resentment, or control. Most states are going to use the child support guidelines for their state. It is very easy to go online and Google your state guidelines. So you just go to Google, type in your state plus child support guidelines. You can find the entire rule as well as a calculator that you can use to import the number of children that you have, the income that he has, the income that you have, any additional children that you or he may have, who pays the medical premiums, and if there's any childcare expenses or extraordinary expenses. And then you hit compute, and it will tell you what his child support obligation will be. Okay, child support is mandatory. It is not optional. Child support is due from the date that you all physically separate or you are no longer living together. And if you were never living together, then child support will be due the day your baby is born. Okay, so what counts as income and how do we prove it? So if he's a W 2 employee, right, he receives a W 2 at the end of the year. He goes to work every day, he works from 9 to 5. Then he gets a W 2 at the end of the year. If he is a W 2 employee, income is not just what shows up on one paycheck. Okay, we want to have multiple paychecks to show whether or not he's receiving any types of overtime, commissions and bonuses, whether he's salary or he works on an hourly wage. Maybe he's underemployed. Is he working full time? Or is he only working 10 hours a week? Is he receiving incentives or reimbursements, differentials, stock awards, or RSUs once they're vested? Does he receive any employer paid perks that reduce his personal expenses? For example, a cell phone. Or perhaps he gets 100% paid health insurance benefits, or he receives a company car, or maybe his employer pays for a gym membership or something like that. Any type of benefit that he receives from his employer that he does not have to pay for himself. Those are in-kind benefits. Many courts are going to consider any and all forms of income that you are receiving as part of your income. And most child support guidelines are going to include as income any and all forms of income, including gross income. So this is not after taxes. This is not net. This is gross income, all income that you have. This also includes gifts. So if he is receiving free rent, maybe he lives with his parents, so he doesn't have rent, or he's getting groceries, or he's living with someone, a roommate, and they're helping to contribute to the utilities, the gas, water, or the electricity. You can figure out what an estimated amount would be for him monthly for those expenses and attribute that to his income. So how do we prove W 2 income? You don't need to argue his income, you document it. Courts will commonly look at pay stubs over time. In my jurisdiction where I'm from, we usually are going to ask for the last 3 months of pay stubs. We don't want just one pay stub unless it's the year end pay stub. And the reason we don't want one pay stub is maybe he's received sick time or vacation time or a bonus or other incentives that are not going to show up on just one paycheck. Now, they'll probably all show up on a year end, like a December 31st paycheck, because it's going to have year to date income on it. But let's say you're at the beginning of the year or in March. It's not necessarily going to show all of those things. So we want to have multiple pay stubs so we can show what he is receiving over time. We want to have a copy of his W-2s. We want to have a copy of his tax returns. Perhaps, if those are not available, an employment contract or an employment offer, a job offer. Historical earnings. I really like to have multiple tax returns to show whether or not he's intentionally suppressing his income. So maybe his income for this year is $40,000, but his income last year was 80 and the year before that was 130. That tells us a lot about whether or not he's intentionally trying to suppress his income in order to avoid a child support obligation. So we want a little bit more data than maybe just one W-2, one tax return, or one pay stub. Courts care far more about patterns than excuses. And many courts, in fact, will have local rules about what's required in child support cases and what's required to be produced. So look, like, what is your county? Google your county plus local rules of court and see if there are any required financial disclosures that he is required to produce if you have a child support case. You will also be required to produce those documents as well. But finding out what his W-2 income is and what all of his gross income is will help you in calculating a fair amount of child support. Now, what if he is not a W-2 employee? Perhaps he's self-employed, or maybe he's receiving disability of some kind, or he's retired. This is where abusers most often hide income because it feels complicated, right? There's a lot more documentation that's involved in order to be able to prove his income. And it can be very intimidating, especially if you're representing yourself. So this category includes business owners, independent contractors, consultants, commission-based workers, and then cash-based earners. And a lot of men who are trying to avoid a child support obligation certainly are trying to earn money under the table. For non-W-2 earners, income is not just what someone claims they take home. It includes what the business earns and what it pays for. So income may include business profits, owner draws, distributions, retained earnings, cash deposits, personal expenses paid by the business, vehicles, phones, travel, meals, housing, a health insurance benefits. If the business is paying his personal bills, that is income. So you need to get a copy of not only his personal bank statements, you also need to get a copy of his business bank statements. And you need to go a minimum of at least 6 months back. You need to see what the business is paying for. You also need to see if there's any commingling of funds. Is he mixing his personal bank account with his business bank account? Is he paying for things from the business? Like, for example, is he going to the store and buying kitchen supplies or groceries or office supplies? Maybe he's buying gas for his car, or there's maintenance for his car that the business is paying for that he doesn't have to pay for. Perhaps he's making his car payment through the business or car insurance through the business. These bank statements will help you determine what benefits is he receiving through the business that he does not have to pay for himself. You can add these benefits, again, we call them in-kind distributions or in-kind income, back into his income to determine what his actual gross income is. Basically, we do a smell test when it comes to income and family law, right? If he's driving a BMW, if he's wearing really nice suits, if he's going to expensive restaurants, if he's taking a lot of luxury vacations, if he has a boat, if he's living a life that looks like it's above his means, but he's claiming that he's destitute and poor and he can't afford to pay you anything, that's not passing the smell test. So there's probably something in his bank accounts that's going to show you that he is spending a lot more money or bringing in a lot more money than he tells you he is. I like using bank statements far more than I like using income taxes. Income taxes do not tell the true tale about what a person's income actually is. I like looking at bank statements to show over a period of 6 months what are they actually inputting into their bank account. I make a chart and I say January, February, March, April, May, June, July. That's 7 months. But what's the income for each month? What are their expenses each month for both the personal and the business accounts? What is their inflow and outflow? And is that reflective of what they're actually filing in their tax returns? If it's not consistent, there's a problem. I would ask the court to consider and use his bank statements as reflective of his actual income versus his actual tax returns. If he's bringing in $10,000 a month in income, he's probably bringing in $10,000 a month in income. So, another truth that you need to know about as it comes to child support is you're entitled to retroactive support or arrears. This means back support. So, another thing abusers don't want discussed is what they owe you from the date of separation or from the date that child is born. In many states, courts can order child support retroactively, often back to the date the case was filed, separation occurred, the child was born, or support was first requested. Delaying or refusing to pay early doesn't erase responsibility, it often creates debt for the abuser. When support isn't paid, it doesn't disappear. It becomes arrears or retroactive support. So arrears are enforceable. In some cases, interest may apply, and excuses don't eliminate them. Abusers rely on women being too overwhelmed or afraid to track missed payments. So, documentation turns non payment into accountability. Make sure from the date of separation or from the date that your child is born, you are tracking every single month and what he is paying you or what he is not paying you. So that if you need to file a claim for child support, you can tell the court exactly what he's paid. If you do not have the funds to hire an attorney, there is child support enforcement in every state in this nation and in other countries. It's called different things depending on where you live. But child support enforcement is a very affordable way for you to file a child support action. In the state that I am in, I'm in North Carolina, it is $25. They will assign you a caseworker and an attorney, and they will prosecute your child support action for you from the day you file it until your child turns 18 and graduates from high school. An order without enforcement is just a piece of paper. And so through child support enforcement, they can do wage withholding, contempt proceedings, arrears judgments, license suspension, tax refund intercepts, and credit reporting. They can help you get the child support that you are entitled to, and they can go across state boundaries. So if he lives in another state than you do, they can go to that other state where he lives and ensure that you get the child support that you're entitled to. And you'll have a caseworker and an attorney to represent you, so you won't feel alone, overwhelmed, or underrepresented in that process. So it's protective. Child support enforcement is there to help you. So, another truth about child support that abusers don't want to let you know is that attorney's fees can sometimes be awarded. And many times, when reasonable child support has not been paid or they shirk their responsibilities to their children, attorney's fees will be ordered. In many jurisdictions, courts may order one party to contribute to the other's legal fees, especially when there's financial disparity, bad faith, or obstruction. Dragging out litigation, hiding income, forcing unnecessary hearings can backfire, and refusing to pay child support that's mandatory can cause a court to order him to have to pay your attorney's fees. Attorney's fee statutes exist, so one party cannot financially exhaust the other. Abusers want child support to stay emotional, chaotic, and confusing. Your power comes when you move into law, math, documentation, and enforcement. If your boundaries keep getting trampled, it's often because they're not anchored in law. Another lie abusers often will tell that I want you to be aware of is that we basically share custody of the children, so I don't owe you any child support, right? I have them about the same amount of time as you do. Child support is based on the number of children that you have and also your incomes. So if he is earning a significant amount of money more than you, he is going to owe you child support regardless of the custodial schedule. Think of it this way. If you're a school teacher and you're earning $40,000 per year and you're married to Bill Gates, do you think it's fair that he shouldn't have to pay you any child support? Of course not. He makes so much more money than you do. In order for your children to sustain the same type of lifestyle that they do with their dad as they do with you, you're going to need some form of child support to make that happen. So your $30,000 income is not going to match what he's making. So it's based on income and it's based on overnights and the number of children that you have. But when your income is so disparate or so different from each other, there is a good likelihood that he is probably still going to owe you some child support. So go into Google again and do your state child support guidelines and then try to do a calculation and see what it is that he might owe you. Don't let him manipulate you and lie and force you to accept a figure that's far beneath what you are entitled to legally. Everything I've shared today is general legal education meant to help you understand the system, not advice for your specific case. If you need legal advice, I strongly encourage you to consult with a qualified family law attorney in your state who can review your facts and guide you appropriately. Inside Live Free Legal Coaching, we focus on education, preparation, and strategy so women can walk into court informed instead of afraid. If this video helped you, please like, subscribe, and share it with a woman who needs it. And I'll put the Live Free Legal link below so you can learn more about what services we can provide and how we can help you defeat your Goliath in court. We post a webcast every week on Tuesdays at 7 p.m. Eastern Standard Time. We hope that we will see you then.